Hey guys, my name is Tyler Potts. I'm going to be doing a series on the law behind various issues that are popular in our culture and in the media. The first topic of this series will be anti-discrimination law. And I'm going to do it in two parts. I'm going to do the first part, the history and kind of the framework of anti-discrimination law and why we needed a Civil Rights Act of 1965 and then subsequent additions to it like the American with Disabilities Act and other acts that added to it. And then the second part is going to be about the modern landscape of anti-discrimination law and why the issue seems to come up continually with, in cases like the Masterpiece Cake Shop case with homosexual discrimination. And to start off, just to give you a definition of anti-discrimination law, one that I came up with to reduce it down to its simplest aspects, I think, is law that attempts to curtail behavior that denies equal protection on the basis of an immutable trait. And by immutable trait, we in the law business generally mean a trait that's inborn or that you can't change about yourself, like your race. And this isn't to say that anti-discrimination law attempts to stop all discrimination, merely the type of discrimination that we as a society deem to be harmful. So you can think of discrimination on the basis of you not wearing a shirt in a restaurant as being very different from discrimination on the basis of your race or your religion or your gender. And then there's also, as far as the law is concerned, the distinction between state discrimination and private discrimination. So with state discrimination, you have the state saying, or the federal government saying, you can't do a specific behavior. Whereas in private discrimination, it's a little bit trickier because you have private citizens in their individual capacities discriminating against people on immutable traits. And to get you guys up to speed, you have to first look at the constitutional history of discrimination law and why subsequent attempts to fix the issue ultimately ended up failing multiple times, and we kind of would find ourselves back at square one after various attempts. So we're going to go all the way back to the founding of the Constitution, or just after the ratification of the first 10 amendments to the Bill of Rights. So you have a Constitution that's set up to structure a government and to protect certain rights in the Bill of Rights. And when you look at Articles 1 through 3, for example, you're looking at Article 1 that deals with the structure of Congress, Article 2, the President, Article 3, the courts. And these aren't concerned with, the states or the actions of private individuals. Article 4 is concerned with the states in some respects. It requires states to give full faith and credit to the judicial rulings and other proceedings of other states. It requires fugitive slaves to be returned. It grants privileges and immunities, meaning you can't basically stop somebody from traveling into your state to pursue whatever occupation they're doing nationwide. It ensures Republican form of government and sets up the process for admitting states. And by Republican form of government, that just means they can't have a dictatorship. States have to have a Republican form of government in each state individually. And then Article 5 deals with amendments to the Constitution. Article 6 ensures pre-war debt was paid. Article 7, ratification. And the first 10 amendments are dealing with, namely, your rights under this new Constitution and to ensure that the system of federalism remains intact with the federal government, having specific enumerated powers and then all the other powers being reserved to the states. And then you have to look at next why this structure not necessarily failed, but it just really wasn't concerned with an overarching federal framework for eliminating discrimination. So first, Congress isn't really provided with a specific mechanism to regulate discrimination itself. So when you think about it, Congress has specific enumerated powers in Article 1, Section 8, and anything that's outside of that powers, technically they can't touch as a Congress because they have specific enumerated powers, like I just said. And then even if they had such powers, they wouldn't have applied to the states originally anyway, so any law they would have passed would have just applied to the federal government itself, which doesn't take us very far when most discrimination probably was happening at the state level. I don't have the numbers on that exactly, but it's a safe bet. And then subsequent amendments to the Constitution didn't initially go far enough in fixing the problem. And we'll get to those subsequent amendments next. You have the 13th, 14th, and 15th Amendments, which is kind of the new founding of the country after the Civil War. And you have the 13th passed in 65, the 14th in 68, and the 15th in 1870. 13th bars slavery, 14th mainly it does a lot of things, but we're concerned with equal protection, due process, and partially the Privileges and Immunities Clause, which it's not really that relevant now, but for our purposes, it kind of is. And then the 15th bars denying the vote on the basis of race. So after basically 1870, you get the 1875 Civil Rights Act, which is very similar to the Civil Rights Act of today. So you have, on one side, you have private discrimination and state discrimination, and you have these three amendments plus the Civil Rights Act of 1875, which function to ban discrimination in public accommodations by private business owners or private individuals acting in public accommodation, which is very similar to the Civil Rights Act of 1965, excuse me. So on the state side, this still failed, though, for a couple of reasons. One, the 14th Amendment doesn't specifically say what equal protection means and the extent to which you're granted due process and the extent to which you're granted equal protection. So the first test case that comes up to the court basically asking the court to define the limits of this amendment is the Slaughterhouse cases. And in these cases, basically, the court's looking at the extent of the rights protected from state interference in this new 14th Amendment that's just been passed. So you have basically what rights are you granted under this 14th Amendment? And in 1873, the court comes back with a very, very limited reading of the 14th Amendment in the Slaughterhouse cases. And remember, under Marbury versus Madison, the court gets to interpret what the Constitution means, and they're basically interpreting what the 14th Amendment means. So they're determining that basically the 14th Amendment grants you only very, very limited federal rights against intrusion, like the ability to go to the seat of the capital, the ability to traverse the nation's waters, and basically the ability to traverse the nation. So these are very, very limited rights as compared to, say, you're protected from discrimination on the basis of your gender. You are entitled to the right to an abortion, like the kind of broad, substantive, and equal protection due process rights we have today. It didn't start out that way. It started out very, very limited. And then you also have in 1896, as far as state discrimination goes, the Plessy v. Ferguson case, which is very famous, and it sets up the separate but equal doctrine, basically saying that, listen here, you as a black person living in segregated South or North is in a separate but equal situation, and therefore you're not being denied equal protection. And then there's this argument that comes up in Plessy about basically the stigma, that the mere separation causes a stigma that causes a lack of equal protection. And the court comes back and says, no, stigma doesn't count. This is separate but equal. So on private discrimination by the turn of the 19th century, you basically have a situation where it's been, or not private discrimination, excuse me, state discrimination. It's effectively very, very difficult for Congress, even if they have the political will, to essentially cut out the evil of state discrimination, because the 14th Amendment has been read so in such a limited way, and Plessy basically allows racial segregation, which allows a lot of discrimination on the basis of race in the states. So you have, legalized discrimination at this point in time. And then you might be thinking, well, what about the Civil Rights Act of 1875 for the private side, which says basically that, you can't discriminate on the basis of someone's race in public accommodations. Well, this also goes to the court in the civil rights cases. And the court says, no, Congress, you couldn't pass this law because under the 13th Amendment, you do have the right to legislate to eradicate, or you have the right to legislate consistent with the language of the 13th Amendment, Section 1, which is what bars slavery unless you've been duly convicted. The court says, though, that provision doesn't mean you can legislate the downstream consequences of slavery, like discrimination, lack of access to housing, things like that. So Congress was basically saying, this is a downstream consequence of slavery, and it's akin to slavery, but by a different name, basically. And the court says no, they mean literal slavery, as in Congress could pass a law banning like peonage, which is something that came up after. But they could not pass a law saying you can't discriminate against people reaching into basically private actions. So that gets struck down. And basically by the time we get out of the 20th century, or 19th century, we're in a situation where private discrimination is pretty rampant, and state discrimination is also pretty rampant because of court decisions and the lack of political will to really fix it, and also just the structure of some of the language that was passed in these laws and the arguments they made that have consequences. So then we get to a situation where it turns around with the civil rights era, basically. So we have Brown v. Board, which is a case we've all heard of, but basically it's overturning Plessy in that it's giving the 14th Amendment a much broader reading of rights that you have. This is the Warren Court, definitely our most liberal court probably ever in the nation's history. We haven't had one like it since, where basically they're saying separate but equal is inherently unequal, and there is an inherent stigma in segregation that makes it inconsistent with equal protection under the 14th Amendment. So this is basically a period of time where the 14th Amendment is being broadened to include things like abortion, contraception, things like gender being protected at a lower level of scrutiny, and things like the right to raise your children how you see fit to a certain degree, all these things in the private paradigm of like reproduction and in that nature. So you have basically state discrimination, the court saying, no, you can't do this, which it formally ends it as far as the Constitution is concerned, but these things still have, you have to have political and cultural will behind them. So it takes a while for things to change as far as the state goes. And arguably, you could make a lot of arguments that some of these things never really did change, even though they were overtly cut out. So then you have private discrimination still going on past this point, because you remember the civil rights cases still basically say that, and there's no other civil rights law on the exact point of private discrimination in public accommodations. There's been 8 civil rights laws overall, but up to 1965, none of them reached to where the Civil Rights Act of 1875 actually went. So the Civil Rights Act of 1965, how it functions basically is, it says that you basically cannot discriminate on the basis of, so you can't discriminate on the basis of gender, national origin, race, and religion. And it only matters in places of public accommodation. And this is spelled out in the statute itself if you want to look at it. But they're generally places like hotels, theaters, restaurants, places of employment, places of education, universities, things of that nature. So you can't discriminate in those places. And then, of course, like all these other laws, it gets challenged in court. In Heart of Atlanta Motel, where basically a motel owner challenges the law on various different grounds. And also in Katzenbach v. McClung. And they both make similar arguments to the court. Essentially, the argument we're concerned with is how the Katzenbach, who was I think he was the Attorney General during that period, yeah, he was, how he basically defends these laws. And he makes the argument, he has essentially 3 options, but he makes the argument of the Commerce Clause primarily. But he also has the option of saying a very convoluted 14th Amendment argument, which is tried in the case, but it's not really focused on when we go back and read through it in history. And there's also a 13th Amendment argument, which is what they had tried in the Civil Rights Act of 1875. So he goes with the Commerce Clause argument and says, listen, interstate commerce has such an effect, a substantial effect on discrimination has such a substantial effect on interstate commerce that Congress can regulate it, regardless of the fact that they're regulating morality, which looks like police powers, which are generally reserved to states. And then there's the 13th Amendment argument, which is basically that slavery is the same as discrimination. They're just one form of downstream consequence of the other. And then the 14th Amendment is basically that these public accommodations are acting in like a quasi-state role, where the state basically, they're almost functioning in such a way that people rely on them like they would the state almost, is kind of their argument, which is not a good one if you ask me, but I think they were just throwing things at the wall to see what would stick. But the Commerce Clause argument does stick, and the court says, yes, there is such a substantial impact on interstate commerce from discrimination that this is something you can regulate. So basically, the laws are upheld, and then we have this period where it's expanded to things like disability, veteran status, familial status, and genetic information status. But basically, that's where we're at as far as the modern, simple framework of anti-discrimination law. Obviously, you could go much deeper into the titles and everything, but this gets us up to speed on where we are now and why there's conflicts between basically homosexual customers in certain states, and why people are making these First Amendment arguments of artistic expression and whatnot in terms of discrimination. Thanks, guys. In part 2, we'll go over some of those modern cases and exemptions from generally applicable laws.